There were two vehicles traveling on Monroe Road near Pentwater, Michigan. At some point, we believe that the defendant's vehicle crossed over the center line, running over a gentleman on a motorcycle, which resulted in his death. Subsequent testing indicated that the defendant had cocaine in his system.
The matter of People's State of Michigan versus Andrew James Joldersma. This is case number 2345312. Mr. Joldersma, can you hear me?
I can.
And counsel, may I have your appearance for the record for the court?
Yes, Edward Sternisha, P75394.
But you said your name is Sternisha?
Yes, Sternisha.
Okay, Sternisha. Okay. And then, Mr. Bison, will you place your appearance on the record for the court?
Just 5 months for the people, Your Honor.
Okay. All right. This is arraignment. Mr. Joldersma, you're before the court on a one-count felony complaint. Count one alleges operating while intoxicated causing death. And it reads as follows, that you did operate a vehicle upon a highway, that being Monroe Road, while he or she had cocaine in his body. And by the operation of that vehicle caused the death of Paul McDonald, contrary to MCL 257.625 subparen 4 subparen A. This is a felony, Mr. Joldersma, and it's punishable by up to 15 years in prison and or a $2,500 to $10,000 fine. You could also be sentenced to rehabilitative programs, costs of prosecution, reimbursement of the government for emergency response and expenses for prosecuting the defendant, vehicle forfeiture, if not forfeited, vehicle immobilization. Defendant may be convicted for each death arising out of the same transaction. The court may order consecutive sentencing under MCL 769.36. Mr. Sternisha, how does your client wish to enter a plea at this time?
Yeah, not guilty, Your Honor.
Okay. The record will reflect a not guilty plea. Mr. Sternisha, Mr. Bison, I guess we need to proceed to setting of the bond. What would you like me to know or consider, Mr. Bison?
Your Honor, as far as the factors for the court to consider, the only one that the people have any knowledge of is prior record. It does appear that the defendant in this case has two prior OWI convictions, one from 2007, which was an OWI, and I believe that was an OWID, and in 2008, he had an OWI. We are not familiar with his work history, his employment history, his time in the area. However, the two convictions would indicate that he's been in the Grand Rapids area since at least 2007. Other than that, we do not have information that the court is supposed to consider.
Okay. And you were cutting a little out. Is he a resident of Oceana County?
No, Your Honor. He's a resident of Sand Lake.
Of where? Spring Lake?
Michigan.
Okay.
The Grand Rapids area. Okay.
And then, all right. What can you give me just a, I know probable cause has already been standard, but just a brief summary of the case for bond purposes?
There are two vehicles traveling on Monroe Road near Pentwater, Michigan. At some point, we believe that the defendant's vehicle crossed over the center line, running over a gentleman on a motorcycle, which resulted in his death. Subsequent testing indicated that the defendant had cocaine in his system.
Okay. All right. Thank you, Mr. Bison. Mr. Bison, do you have any specific bond recommendations to make?
I would leave it to the discretion of the court, Your Honor. I believe that all of the information we have given the court. Two prior convictions should be factored into the appropriate bond consideration. but there's a lot of information that I don't have, and I'm not going to misrepresent anything.
Okay. Mr. Sternishaw, what would you like me to know or consider?
Thank you, Your Honor. Thank you, Mr. Bison. Your Honor, as the court knows, when it comes to setting of the bond, the court doesn't consider any penalty because he's innocent. There's two factors that the court's supposed to consider. One is the safety of the public, and the other is to ensure that the defendant appears in the future. I think it's clear that he's going to appear in the future. The second prong of this, he's already retained an attorney. As soon as he was informed late Friday of the charges, instead of letting me have a court-free holiday week, he wanted to be here first thing Monday morning. He turned himself in. He was not picked up by the police. He turned himself in here today to the court, walked over with me to the sheriff's department to be fingerprinted and have his mugshot taken. It says a lot because, Your Honor, he's going to appear. His wife also appeared at the court. She, of course, because it's by Zoom, is sitting in the hallway watching the proceedings. His uncle is also here. He's got a good job, Your Honor. He has, as far as his appearance in the court, to any court proceedings, he's not going to flee. He's got everything here. He's a lifelong resident. Even if you consider his prior convictions, there's no history of failure to appear. So for that, Your Honor, I think that's an important factor. And as far as the safety of the public, Your Honor, fortunately, as we can see, courts now use technology. I mean, we're doing it right now. There's instead of locking him up until his trial, there's all kinds of things that the court can do, including electronic monitoring or weekly testing. Although he lives in Kent County, Your Honor, he's driven a couple counties over to get here today. He'll do that every time. He'll go to any testing, alcohol, drug testing that the court would require. And his job, his employer's also already been doing weekly testing since this incident because they're concerned too. They want to make sure that that's not an issue for them. So the other thing I want the court to consider is we wanted to get treatment. When I talked to the police chief about this on Friday, when he informed me of the charges, I know he shared some concerns with me that, well, that he might not turn himself in because I've had in the past where people go and get into counseling so they don't have to. Well, he turned himself in, but the other thing is we want him for public safety. It's a good factor that he does get into treatment. So, Your Honor, I asked for a PR bond or with maybe testing, regular testing or electronic monitoring so he can continue his employment, take care of his family, and he will appear in court, Your Honor. Thank you.
Okay. Number one, how you say he's a resident of what county?
Kent County, Your Honor. He lives in Sand Lake, which is it's kind of on the border of Kent County and Montcalm County. It's on the north end of Kent County. Okay.
And how long does he own his house? Well, how long has he lived there?
Yeah, they just bought it 2 years ago. They do own the home. They bought it 2 years ago.
Okay. And what is his job? You indicated he has a good job. What is his job? What does he do?
I'm the assistant manager at a landscape company that I've been with for 22 years.
Give me just one moment. I just want to double check this date.
And if I may say, we have no problem waiving any time limit requirements if the court needs to extend it.
So
we have no problem waiving the 21-day limit. It gives us time to prepare. This is a serious case. We don't have any information on it yet, and it would give the prosecutor and I some time to share information that's needed. So we can waive the 21-day rule, so it also works with the court schedule.
All right. Well, we do these on Tuesdays And I'm here, you know, every Tuesday for the month of July into the late week, last till the third week of August. I think I have one of those Tuesdays off, but let me go through the bond conditions first. So these are going to be the standard conditions of bond, and then I'll let you make. I always like to give both sides a say. Mr. Bison had his say. You had your say. Since it's your client, I'll let you have one last statement, Mr. Sternshaw. But let me first say this, that the defendant shall comply with the following terms and conditions of bond. Number one, Ms. Facundo, 4A will be checked. That is to personally appear for any examination, arraignment, trial, sentencing, or at any time and place as directed by this court. If you're represented by an attorney in this case, which you are, any notice to appear may be given to your attorney instead of you. So that Mr. Joldersma, you need to stay in contact with your attorney so you can he can ably and capably represent you, number one, but number two, so that you'll get your notices to appear. Number two, you need to abide by any judgment entered in this case and surrender to serve any sentence imposed. Number three, you're not to leave the state of Michigan without permission of this court. Number four, you're not to commit any crime while released. Number five, you're to immediately notify this court in writing of any change in address or telephone number. Now, this is very important. Number one, box 4G should be checked, Ms. Facundo. You're not to use alcohol. That means you're not to possess, purchase, or consume alcohol. You're subject to random testing at the request of this court or any law enforcement officer. Failure to test or a positive test could result in revocation of your bond. Do you understand that, sir?
I do, Your Honor.
You're not allowed to use marijuana. That is, unless you have a valid doctor's prescription. It's the only circumstance you're allowed to use marijuana. And then if you do have a valid doctor's prescription of marijuana and you use it, it must be in compliance with your doctor's recommendations. Number three, obviously no illegal controlled substances, because use of an illegal controlled substance obviously violates the previous under 4D, which is not to commit any crime while released. Is there any other bond conditions you wish me to consider, Mr. Bison, in reference to substances or substance abuse? What was that?
I believe the court has covered them adequately.
All right. All right. Now, the final setting of bond. I understand your arguments, counsel. However, a person is dead, number one. Number two, your client has had two prior instances of operating a motor vehicle while intoxicated. Therefore, I find release on personal recognizance will not, number one, reasonably ensure public safety. I'm not granting a PR bond in this matter. Number two, because this is a very serious situation, there's always concerns. Now, while I appreciate Mr. Joldersma's turned himself in today and has hired counsel, I commend him for that, but still the consequences for an OWI causing death are serious, and therefore to a lesser degree than public safety, but still the court has to acknowledge that appearance whenever anybody's charged with a very serious matter is always a concern. So I will check both of those boxes, Ms. Facundo, 1B, appearance and public safety. I'll give counsel for both sides to make their final recommendations to the amount of bond, but there is going to be a bond set on this case, and it will not be personal to Cognizant. Mr. Bison, anything else?
Your Honor, in general, I've always been satisfied with the bonds that this court sets. I've seen you set bonds before. I'm not asking the court to go outside of your normal parameters. I think where you normally set bonds in cases like this is appropriate, and I would leave it to your discretion.
All right. Is Mr. Sternishaw, what would you like me to know or consider?
Your Honor, I appreciate what Mr. Bison says as well. I've only been in front of Your Honor once or twice in the past. I respect your decisions, Your Honor. I asked for at least a cash surety bond that's in a reasonable amount that his family can post that, and yet he can still get to work.
Okay. I'm going to set taking in all the factors on this into consideration, taking in the factors of public safety into consideration in the defendant's prior record and the factual summary that the court has heard today. I will set the bond in the amount of $100,000. That'll be cash surety or 10%. And that'll be the decision of the court at this time. Mr. Sternishaw, you can always renew your motions for reduction of bond if your client doesn't post his bond, either at the probable cause conference, which we will set shortly, or the preliminary examination. Based on that, what do you wish to, I'm happy to set whatever dates are available on a Tuesday or Thursday. We can definitely do it within the 21-day time period, Mr. Sternishaw. I'm not trying to force your client's hand one way or another in waiving the 21-day rule. We'll make sure that the preliminary examination is done within 21 days. What is your position on, do you still wish to waive the 21-day rule, or do you want to, I mean, we had the dates proposed July 18th and August 3rd, but we're happy to go with a shorter time frame to comply with the court rules in reference to the 21-day rule.
Well, yeah, I mean, as Mr. Bison, as far as the probable cause conference, I'm looking at my calendar and I see I have something on the 18th, but I can't open it because I don't have a signal here. Is that something that you're willing to do via phone or Zoom or email? If so, then the first, setting the prelim for the first, as far as I'm concerned, I don't have anything on the first, and I would rather him do it sooner than later since he is in custody on a high bond.
PCC, you've allowed attorneys to do that by Zoom before. As far as my part with Mr. Sternishaw, we would just need to have a conversation, which we can do by phone and email. And then you can inform the court what you want to do as far as the preliminary exam. As far as dates, I'm amenable to what the court needs. We had actually discussed with the chief of police not having an arrest this week to give us a little more time, because right now, Your Honor, the date that would be within the 21 days would be the 18th, because even the 25th is more than 21 days out. But Mr. Sternishaw also mentioned discovery issues. We will begin immediately getting stuff to Mr. Sternishaw as soon as possible. We believe that we would have enough to move forward on the 18th with an exam if needed. But there's more coming in. The nature of evidence today is more complicated than it was 20 years ago. It will continue to come in. So we're gonna have to deal with that issue as well. But as far as dates, I leave that to what is most appropriate for the defense in this case. We will be ready when we need to be ready.
So we can, to answer your question, Mr. Sternishaw, I'll approve soon for a PCC, for the probable cause conference. We can do that on the 18th by Zoom if that opens up your calendar. The real question for you is if you want August 1st then we would need a waiver of the 21-day rule. If you want July 25th, we're happy to do that.
Your Honor, August 1st works for me, for you. Yeah. So August 1st works for us at this time, Your Honor.
Okay. So is your client therefore willing to waive the 21-day rule to accommodate your schedule and allow extra time for you to be prepared for the preliminary examination?
Yes, Your Honor. Okay.
All right. Has anybody forced, threatened, intimidated, or coerced you into waiving the 21-day rule, Mr. Gildersma?
No, Your Honor.
Okay. Do you believe this is a voluntary waiver, counsel?
I do, Your Honor.
Okay. Well, then the 21-day rule will be waived for good cause to allow preparation for the preliminary examination. So that means we can do the probable cause conference either on the 18th or the 25th. Which parties rather do?
I believe I don't have anything on the 25th. I don't think, I just don't know what it is I have on the 18th. I apologize. It won't let me open it. But it tells me, you know, there's a dot there, so I know there's something. But the 25th, I think, would work for a probable cause conference.
Okay. Do you still want to do it by Zoom, or do you want to do it live and in person since you have an opening in your schedule?
I can appear in person, Your Honor.
Okay. All right. We'll have the probable cause conference then on July 25th and August 1st at both are at 1 o'clock, and August 1st will be 1 o'clock. And is there anything further, Mr. Bison?
No, Your Honor.
Anything further, Mr. Sternishaw?
No, Your Honor. Thank you very much.
Okay. Well,
Mr. Bison, I have the my appearance in discovery. I'll bring over in a few moments.
Thank you.